Take a simple case of theft or robbery. We charge the thief or the robber. Then what will happen to the robbed money? First, you have to prove the case in a criminal court and prove beyond reasonable doubt that this person has robbed the money. Then there has to be a conviction of robbery. After the robbery conviction is only, court will decide this robbed money probably recovered from the robber, whether to whom that is going to be handed over. That is called disposal of property. So without having a conviction, you can't do anything with the robbed money. That is the general law in this country.
She talked about a rebuttable presumption.
Yes.
Yes, and also there is another provision in Money Laundering Act, Prevention of Money Laundering Act, Section 3, subsection 3. It specifically says, there is no need of having a conviction for the predicate offense to proceed with the money laundering offense. So when it comes to money, this I really completely agree with Mr. Jayamanne. That is the norm. General law. However, there are special provisions in the Prevention of Money Laundering Act to overcome this issue.
Sorry, Sarath, I won't interrupt you again.
No, I want to systematically explain to the audience. However, the anti-money laundering law was introduced with this difficulty. But the problem in the anti-money laundering piece of legislation is the prosecution has to prove this money has been laundered. Without proving the element of laundering, you can't prove the prosecution. Then though there's a presumption, on paper it is so sweet. Always we get the feeling the moment the case is filed, the presumption would be applicable. In practice, it won't. Why? Just because the perpetrator has assets, court is not going to draw that inference. It is illegally obtained assets. Why? There is a duty cast on the prosecution to show this particular the accused has the means and the capacity to commit a particular criminal offense of bribery or corruption. Without having that link, you can't draw that inference. That is one of the reasons I know the acquittal of a particular politician in the recent past. So therefore, this difficulty is in the Anti-Money Laundering Act. Now what we have done? Now we are going to introduce a Proceeds of Crime Act. There was a committee consisting from various stakeholders. We sat for more than 1 year, headed by Justice Yasantha Kodagoda, and we prepared a report by the 10th of April last month and submitted to the Cabinet, and Cabinet has approved. Now the legislation is being drafted by the legal draft person. What is the purpose of having Proceeds of Crime Law? Proceeds of Crime Law means basically if a particular person has particular assets, and if the investigator thinks there's a reasonable suspicion this has been acquired through a proceed of a crime, that means he can basically start an investigation after getting the necessary approval. During the course of the investigation, they will collect material and you have to give an opportunity to the accused to explain how you have got these assets. If he fails to explain, what will happen? He will be prosecuted for in possession of proceeds of crime. So once you prosecute, once there is a conviction, what will happen? After the conviction, there will be basically a forfeiture of those assets. Then we have introduced a new mechanism also. There are certain cases you can't prosecute an offender, but we know this is ill-gotten money. Then what are we going to do? We are going to have a non-conviction based prosecution. What does that mean? We are going to have a conviction against that particular property. Why? Then the prosecution need to prove the case only on a balance of probability. We have an asset and we have evidence that there is no legitimate means of securing these assets, then what happened? We go for a non-conviction based prosecution. After the non-conviction based prosecution, that asset can be forfeited. So that has been introduced in the new system. So with this law, once this law come into operation, I think all the difficulties we had under the Criminal Procedure Code, all the difficulties we have had under the anti-money law will be reduced. Other feature is in this new Proceeds of Crime law is the investigators have been given so much power, and when they conduct investigation, they can basically go and seize the property. Not only seize, they can give an order called some kind of a prevention order, restraining order. They can ask the perpetrator not to do anything with this property, not to transfer this property. Thereafter, you can go before the courts and take a basically legal freezing order. Why? We want to keep this property intact till the final conviction. Once we take the property, what are you going to do? We have to manage the property. Take an animal farm, take a factory. Just because investigators go and seize, can they manage? No. There has to be a management authority comprising of experts. That is also provided under this act. Then when you introduce these acts, you have to be mindful. There are competing interests. There may be innocent receivers. Their rights have to be protected. Sometimes overzealous investigators go and arrest this property, seize this property. You have to protect those. So there are certain competing interests, and we have looked at the law in UK, Australia, and US. We have compared those laws and prepared this law at the moment. And once it is tabled before the parliament, or once it is being discussed by the other members of the society, I think still it is open for more